Good afternoon, everyone, and thank you for joining us for Collaborative Practice 301. In this presentation, the panel will be providing a quick recap of parts 1 and 2 of this series focused on collaborative practice and family law, followed by an extended Q&A with questions we've received in advance from our audience members. So in this session, our presenters will revisit the following topics: what the heck is collaborative practice training, the CP participation agreement, family and financial neutrals, the power of a full team, the role of experts and reports, Runaway trains, an ointment for high conflict litigation, saving the Golden Goose, CP and family run businesses, Impasse and hitting a wall, and selling collaborative practice. And as I mentioned, that will be followed by Q&A. And as we are presenting remotely and during a thunderstorm at that, we apologize in advance for any tech issues that may arise as a result, but we will certainly do our best to try to mitigate any disruptions to the presentation today. And also just another quick note before we get into our introductions. As always, we ask our audience to keep in mind that this presentation is intended to provide general information and should not be considered legal advice. And now I would love to take the opportunity to tell you a little bit about our speakers before I pass things over to them to get started with the presentation. So first, we have Brian Galbraith, who is the owner of Galbraith Family Law, which has 6 offices in Ontario and 16 collaborative lawyers. Brian is the president of the International Academy of Collaborative Professionals and has served on its board for several years. Brian has helped train hundreds of collaborative professionals and conducted workshops on the international stage. Brian has served on the board of the Ontario Association of Collaborative Professionals and was instrumental in its formation. Brian was the chair of the Trainers Committee in Ontario for several years, and he continues to serve as the president of his local practice group. Brian is also a mediator, and most importantly, Brian is the father of 5 children and grandfather to 2 so far. He lives on Lake Simcoe between Barrie and Orillia with his wife, Nicole, and their 2 young children. Next, we have Carrie, and Carrie Heinzl is the founder of Fairmore Family Law Financial Solutions, and Fairmore offers independent, fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level trainings for the seasoned practitioner. Carrie has taught statistics, research methodologies, and psychology at college and university levels. In addition, Carrie has presented at conferences for the Ontario Association of Collaborative Professionals, Family Dispute Resolution Institute of Ontario Annual Conference, and the International Academy of Collaborative Professionals. Jonathan Paynter is a registered social worker and psychotherapist who works in the family court system, completing custody and access assessments, parenting capacity assessments, and youth court assessments. He specializes in cognitive behavioral therapy and couples counseling and holds certificates in collaborative family law, advanced family mediation, family arbitration, domestic violence screening, offender relapse prevention, and actuarial assessment of risk. Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as secretary of the board, as well as being chair of the accreditation and the course approval committees. Next, we have David, and David Cahill is an associate family lawyer and accredited family mediator. He was called to the bar in 2018 and since has been practicing exclusively in family law. David assists clients with peaceful, respectful, out-of-court resolution of their parenting support and property issues. And David's role is to guide clients through their period of transition with separation and divorce. He does so by facilitating a process that empowers his clients to attain a durable and workable resolution. And David strongly believes that resolving family law issues through negotiation, mediation, and/or collaborative law will always be preferable to resolving them through litigation. Next, we have Russell Alexander, and Russell is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them in coping with the difficulties of separation and divorce, the division of assets such as homes and pensions, and the calculation and enforcement of child and spousal support. He uses his experience to create unique solutions for each of his clients to enable them and their families to move forward and supports them through the transition of divorce and separation. And on that note, I will let Russell take it away from here.
Mute.
Got it. Thanks for those kind words. Let's start with our first poll.
Quite the dream team you put together today, Shannon. Thank you so much. While we're
I
waiting,
have to agree.
while we're waiting for the poll, Shannon's going to flip up a slide just a bit, some CP training we've got coming up. Take a look at it. We have some spots available still. So, and I think we're going to have a discount code for people who are attending today if you want to take the training. Please provide us with your feedback. We're going to be running polls throughout today's presentation. You'll get a survey at the end of today's presentation. Let us know what we're doing well, what we can do better. This is an advanced topic of collaborative practice. So the recap is going to be a real quick 1-2 minute summary. If you want to learn more, we have CP 101, CP 201, podcasts, and a bunch of other information if you want the basic details. The CP training is available for Canadians who want to become collaboratively trained, but it's also available this year for Americans. Is that right, Brian?
Yeah, the Americans tend to have shorter courses, and so what we've done is developed our course so that it can be, the short course can be taken by the Americans, and that will qualify them for to practice in their jurisdiction. And in Ontario, we require a longer program, which goes into more in depth, more role plays, more deeper learning. And so people who want to practice collaboratively would take the full eight sessions. It's all done online on Zoom. The sessions are 4 hours each day, and those are the dates that are on the screen there, Russ.
So it's the best of both worlds. If you're Canadian or US practitioner, you can get your training online from home. Let's see who our audience is today. Lawyer practicing family law, 65%. Other area law, 18%. Another professional, 15%. Going through a separation and divorce, 3%. So thank you, audience, for answering. I think we're going to have one more quick poll, and then we're going to get into our recap. So we'll do this one quickly. Do you have collaborative practice training? And we'll give everybody just a moment to fill this out. Then we're going to go into our recap. Again, the recap is just a quick run through. We've got more details in the show notes and more programs you can watch. But today's focus, being an advanced session, is we want to dive deep into the Q&A. So put your Q&A in the chat box. We're going to get to all the Q&As that we can. We've got some that came in advance, and we're going to answer those today as well. All right, let's see who our audience is, please. All right, no, 83%, yes, 17%. Okay, well, you're in the right place if you want to learn about collaborative practice. So let's do a recap of CP 201, CP 101, the basics. What the heck is collaborative practice? Brian, how about it?
Well, collaborative practice is a fantastic way for clients to resolve their divorce and separation related issues without going to court. That's what it's all about, is helping clients resolve their issues without having to ask a judge or an arbitrator to decide for them. And so it's an interdisciplinary process. Each party has their own own lawyer, and then they share together a family professional who is someone with a mental health background, such as Jonathan, who can help them with communication issues, prepare them for meetings so they can get through the meetings without being triggered, and help them develop a parenting plan and help them with communications and so on. They're really important to the process. That person is one person shared, the cost of which is shared by the parties equally usually. And then there's a financial professional like Carrie, and that person accumulates all of the financial disclosure and helps discuss the equalization issues and support issues with both parties. So the two neutrals bring the interdisciplinary nature to the process, which is unique. We don't see that in mediation or in any other process or the court process. It's a team of professionals working together to help the clients resolve the case. And the hallmark of the process is the disqualification clause. And there's an agreement that is signed at the beginning by the parties and the professionals that says, we're not going to go to court. And if the matter ends up in court, then you have to start over with new professionals. And the beauty of that is it really transforms everyone into a deep commitment to settlement.
Yeah, we're going to take some questions about the disqualification clause. Usually that's a big rub for lawyers and clients, but we're going to get into that a little bit deeper later.
Sure.
Brian talked briefly about the training. Carrie, can you elaborate a little bit more? Why do we need training? Why can't I just go in and do things collaboratively? What's this all about?
That's a great question, Russ. Really, we want to do collaborative practice training.
Those lawyers saying I'm going to do, small C collaborative, right?
Yeah.
It's BS. They're just, they don't have the training. They don't even know what we're talking about. Is that right?
Well, exactly. To really do collaborative justice, you really do need to do the training. I always look at collaborative practices that we're mixing the best of all worlds. We're mixing the best of the mediation world and we're mixing the best of the litigation world, and it's coming together so that we can do really focused work on goals and interests so that we have lasting agreements and not something that people are going to go and argue about in a couple of years or even a couple of months for that matter. Getting the training, understanding the principles behind it, what is allowed, what's not allowed. I think it's really fundamental. I've always said it's a great process simply because lawyers actually get to do what they went to law school for rather than doing the care and feeding of a court system. So I think it's a great way to get training.
The other thing, the feedback I've gotten from lawyers who do the training, it actually makes them better litigators, right?
Oh, by far.
They start thinking about the issues differently and they're saying, well, really, what's your client's underlying goals here? What's their concern? So you really think through a file differently rather than horse trading.
Well, Russ, I think you also have to look at who's sitting on the bench right now. Most of the judges sitting on the bench have collaborative training. They understand, and they're looking for that in their litigators, that they actually have settlement in mind and not arguing.
And a lot of them will kick clients out of the courtroom. They'll say, go do mediation, try collaborative training, and come back to us. Usually they come back with an agreement with a dispute resolution clause. They haven't even read it. So the judge says, you have to do this before I'm going to hear your case. But that's a great point. All right. So we enter into contract when we do this process, the participation agreement. David, what do we need to know?
Well, I think the first thing people need to know is if you haven't signed a CP agreement, you are not doing collaborative practice, period. One cannot be done without the other. The agreement is fundamental. And I see it as fundamental in particular because it incorporates and really brings to the fore all the expectations that you want your client to have about the collaborative model, including the onus to act in good faith. And getting it signed at the outset of a file is important because the scope and nature of the communications you will have with other counsel and other professionals will be different in a collaborative model than in a traditional, litigation model or lawyer-assisted negotiations. One of the things that I like to do in my agreements is include a schedule that specifically authorizes the collaborative lawyers to use their discretion in deciding to disclose information discussed between professionals to different members of the team or to your client. And that's a really important feature of collaborative work, is being able to use discretion in terms of when information is shared and how much. So those agreements are so important, get them signed.
The thing I love about it is there's a provision that says we're not going to take advantage of each other's mistakes, right? So when you're litigating, you always have your guard up. You're worried somebody's going to stab you in the back or pull the carpet out from your feet. In the collaborative setting, you can let it rip, right? So we got the number wrong on the end. Deal, we're going to fix it, right?
Figuratively, not literally. Just
well, we're not going to spend 6 months deciding whether we should amend a mistake that was made. It's assumed everybody's working towards a common good, but
absolutely.
Thank you, David. Family and financial neutrals. Jonathan, I'm separating. My wife and I have lawyers. Why the hell do we need to bring more people into the business of our separation? What's going on here?
Yeah, I mean, I think the collaborative approach requires a really big mind shift for people who are used to litigation, because you're actually growing your team by adding a financial and family professional, they can do a lot of the work that the lawyers would do otherwise, but at reduced costs because the parties are both paying towards the neutral's fees. And it's always helpful having a neutral who can take a step back, look at the big picture and say, hey, this is what I think about the situation. So the financial professionals are really, really helpful because they can do a lot of the calculations to your net family property statement. They gather all the financial information about things like pensions. They do the support calculations, and this saves a lot of time and money for clients because you have that specialized person doing that work. And one of the things that I found super helpful for clients with respect to financial neutral is their ability to help foresee the future and say, okay, when you're separated, this is what you need to think about from a budgetary point of view. This is how much money you're going to have. This is the kind of house you can afford. This is the kind of mortgage that you could have every month. And that really helps the parties visualize their goals in a more realistic way, and recognize that, you know, separation is a financial decision as well as an emotional and legal decision, and having an expert help you through those finances can really be helpful. The family neutrals play a very different but also important role. If I was involved in a team, I would help with the parenting plan, which again, lawyers could do fine, but why not have someone who's an expert in parenting and you know, child development, that kind of thing, working on your parenting plan with the clients. Both clients are contributing to the family professionals fees, so that it's cheaper to have a family professional involved doing that kind of work. But also, you know, the most expensive piece of any separation is conflict. And if you can have a family professional there to give advice on positive communication versus negative, how to resolve conflicts, how to make proposals to each other, and guiding the whole process in an amicable way, you're going to end up saving your client a ton of money, and it will be less stressful for them. And also, you know, just to have a full team is very important. Not
I was
just
going to
for
ask
the
you, what's the full team, right?
a
You know,
full team would be two lawyers.
collaborative
One
lawyers talk
represent.
about it, but
Yeah.
what does that mean when you say, okay, we're going to get a full team involved?
So it usually means like two lawyers, one for each client, a financial and a family professional. Sometimes it also involves other professionals like business valuators, pension valuators, appraisers for getting values of the house. It could involve a whole bunch of different people, but
And
usually it means
those
two
financial
lawyers and
those
two neutral.
financial professionals, sometimes lawyers, that's like their business model, right? I'm going to do the financial statement, charge the clients. What you're talking about is one person does a joint brief for the whole team. So they're saving time and expense. Is that right?
Exactly. Yeah.
Okay.
And they're like gathering all the information. If you have two lawyers doing that, they can do that fine, don't get me wrong. But if one person's missing someone, then they have to call the other person, who then calls the client, who then gets the information, and then it goes back to the first lawyer. If you've got a financial person doing that, they're collecting all that information directly for the team. And I do want to mention too, the power of a full team is not just that the clients get all the support that they need, but the team gets the support they need, because, you know, working with separating families can be really stressful for the professionals involved, and having a team approach means you get not just support for the clients, but also for each other as a professional. It's great working as a team. Otherwise, I would be doing this work as a mediator in isolation. I can speak from my own experience. It's definitely not as fun or as rewarding or as easy to do that work on your own when you don't have a team present.
And you don't need children to have a fine family professional. They can help in other ways. Is that right?
Exactly. Yeah, I help a lot with communication when there's high conflict. You know, like I said before, conflict is the most expensive part in separation, and anything you can do to reduce conflict will save the clients a ton of money and a ton of emotional stress in the long run.
All right. So
You know,
go ahead, Carrie.
Sorry, Russ, I was going to say the one thing I've always really enjoyed about having the family professional is their ability to assess the client's readiness for any process, whether it be a court process, the collaborative process, any process. But, we always have one person that's always lagging a little bit behind. And I think they really help a lot moving that person into what we're doing and how we're doing it and getting those emotions in check. That's why I love a family professional.
Well, the neutrals also help keep the lawyers' emotions in check too, right? They'll call it time.
That
Somebody's
is a
too
true statement.
adversarial. They'll call it time and say, okay, let's debrief on what just happened there, right?
Absolutely.
Yeah.
There's a good question too about family professionals dealing with children's interests. And I do want to note that one of the roles that I play often is when parents have older kids, preteens or teenagers, the family professional also get involved in getting the children's views and preferences about, a parenting schedule and any other issues that are important to the kids, and bring that to the table and into the process, which can be a really helpful role that family professionals can play.
All right. So we talked about the participation agreement. We talked about the full team. Now I guess it's going to be an extended team, role of experts and reports. This is going to be yours, Brian. We also had a question that just came in about retainers and how do you pay for all this? How's that shared? Maybe you can touch upon that a little bit too, Brian.
Yeah, I just answered that question.
Okay.
The question and answer, but it's a good question. And the answer is that each party retains their own lawyer, so has a contractual relationship with their own lawyer. And both parties have a contractual relationship with the shared family professional and the shared financial professional. But all four professionals are independent of one another and have separate retainer agreements. So go ahead, Carrie.
Sorry, Brian, I just wanted to add in there, a lot of times what I will do as the financial neutral is I will ask the clients if they have a joint line of credit. It's a great way to pay for your neutrals, and even your legal counsel, they can keep track of what the cost of the process is. And it's also really easy for us to reconcile at the end.
Or oftentimes one party is writing the check to the other party, right?
Yeah.
And that party is going to finance the process, and we agree to divide it at the end of the process and adjust for the fees that were paid. There's simple solutions to the payment problem, I think.
Absolutely.
Sorry, Brian, we keep cutting you off.
That's okay. I was asked about experts, and the vast majority of clients over the years that I've dealt with, and that's hundreds and hundreds of families, they just want to get things resolved. They just want some help, some facts, some information. And so in the collaborative process, we need to sometimes get experts involved, but it's not a competition among the experts. Usually what happens is we bring in experts jointly. So for example, if someone has a business and we need a certified business valuator, then the parties will jointly retain one person to come in and look at the business and really give a neutral, objective opinion as to the range of value as to the business. And they'll come to a full meeting with the clients and discuss their thoughts about the value of the business, explain their reasoning behind it. And sometimes they have to make adjustments based on information they get from the clients at those meetings. But it's not about competing experts battling one against the other. It's about bringing the clients the information they need to resolve their issues. So we'll have experts evaluating businesses, pensions, property, farms, assets, boats, stock options. That's a very complicated valuation process. And so you can bring an expert in for that purpose. And usually that information is kept in the process. It's not brought into the litigation unless the parties agree that it can be. So experts are used as needed.
Keep your questions coming in, audience. We have somebody talking about bringing jelly beans. We've got another one. Basically, it's what do you do about a wolf in sheep's clothing, right? These lawyers who say they're collaborative, but they're not. We're going to get to all these, but keep them coming in. Runaway train, an ointment for high conflict litigation. We've talked about this runaway train forever. We've got programs on it. We're going to include links. I guess the idea here, Carrie, is you take these crazy cases out of court and you bring them into a collaborative setting to solve them. Is that what's going on?
Absolutely. You know, there's so many times when we hear about people going through litigation fatigue, where they've just been going on that litigation train for so long and they just can't seem to get off. One of a great way of doing that is pulling your court matter into the collaborative process. It takes people into a different frame of mind when they're discussing things. We're off of positions, we're into goals and interests, we're into a very settlement focused, in which we're kind of putting them in a room and saying, okay, let's talk this through. Let's get to where we need to be. The only way you're going to get to an acceptable and sustainable agreement is if your clients are actually part of the process and not just being thrown into a process. So taking them out of court, getting them in collaborative, that's that done for them.
Love it. And, you know, I've got clients who've been in court for 2 years. I explained collaborative practice. They said, nobody ever told me this was an option. Just thought this is how they resolve disputes. It's really quite sad because they've now spent $100,000.
Yeah.
And it's just terrible. All right. Golden Goose. What are we talking about here? Family run businesses.
Family run businesses, Russ, the Golden Goose. Everybody talks about when we're going through this process, you have a family run business. There's so many reasons to go collaborative. Number one, it is a nice private process. I know if I have a business and I have competitors and I find out my competitor is going through a messy divorce and they're in court, I want to run down to that courthouse. I'm going to slap down my credit card and go, give me all the information. Because I can find out all sorts of great information about my competitor. So keeping it in the family, in the collaborative process really retains that privacy.
So the Goose is the family run business. And
The
we
Goose
want
is the
to keep
business.
Keep producing income for the family after
Well,
the divorce, because divorces can destroy businesses, right?
100%. And so we don't want to destroy what gave this family wealth. And so the end of the day is what our goal is to let's make sure everybody can come up with that settlement that keeps that golden goose laying those wonderful eggs and giving the family the wealth that they require. Remember, if one of the party owns that business and the other person's saying, give me half of that business, but we've just destroyed all the covenants of the business and the business has to close, how's support going to get paid now? So we need to get creative.
Oftentimes there's adult children working in the business as well, right? It's not just husband and wife or partners.
And this is where we may want to bring in corporate counsel. And let's talk about succession planning for that business. If it's really meant for the kids to have something going forward, we want to be able to develop something in our separation agreements that can go into about the corporate structure, what that's going to look like, what that succession planning is going to look like. Let's marry documents together so that they can't be changed in the future. Remember, wills can be changed. The separation agreement cannot be.
Yeah, great point. And legacy planning, and if they're going to continue on the business, what do you do with new partners who people are repartnered? We've got a whole program on this, but let's go to Impasse. I think this is yours. Is that right, Brian?
Yeah, impasse is when parties get stuck and they can't easily resolve an issue and they hit a wall. And that is normal in any negotiation process. And so that's one of the first things I always do is normalize that for the clients and let them know that might happen. It's likely to happen. And but when you're in the collaborative process, the advantage is you have a full team of professionals. So what we do is we'll come together as a team and discuss where the clients are at and what's causing the impasse. And we'll look at various ways that we can overcome the impasse. And maybe the matter has to go back to the family professional to have a deeper dive into the underlying interests and goals of the party. Maybe there's more financial information that the financial professional can provide. Maybe we need to really get an expert opinion brought in as to whatever the issue is and discuss that further. So we brainstorm together as a professional team to find a way through the impasse. And 86% of collaborative cases result in a full settlement. And so we are able to get over impasse because of the team working together.
You're on mute.
I know. Oftentimes, impasse, there's some underlying issue, right, that hasn't been resolved. And the family professional can dig that up. And I find if you normalize impasse, right, this is a normal part of collaborative practice, and deal with methods to deal with it, like create methods to deal with it, it's quite effective because usually the cases settle very quickly after you get through the impasse. But time for a poll. Let's see what our audience is thinking. What do you think the most difficult part of selling collaborative practice is? So we'll give everybody a chance to answer that. And then we're going to actually talk about selling CP.
So I think you mean selling a collaborative practice to potential clients. Is that what you mean?
Or even the other lawyer or
Ah.
your colleagues, but mainly
Oh, yeah.
usually it's the client sitting across from your desk initially.
Right. Yeah.
And then you gotta get the other spouse on board. And they may not hire a collaborative lawyer, but okay, let's see what our audience thinks.
Yeah. Yeah.
Okay, convincing the other spouse, 44%, cost 20%, other lawyers 16%, your client 20%. Okay, well, if it's my client, I just tell them this is the way it is. This is the way we're going to start. But how do we do this, David? How do we sell CP?
Well, it really does start with you, right? And it starts from that initial consult or conversation you have with your client, right? It's incumbent on you to introduce them to a model of dispute resolution that they might not be familiar with, and to make them feel comfortable with what that process looks like. One of the ways I like to do that is by sending an introductory letter to all my clients, which talks about processes and talks about who I am as someone who is interested in seeking solutions and resolving conflict. And it's an opportunity to invite your client to identify their own values, which maybe they've never really thought about, and identify their own goals. And you can then use those values and goals as an anchor point throughout your period of time in working with that person to remind them of what brought them to you, to remind them of where they hope to go and be, and then link those back to the collaborative process. And in terms of speaking to the other person, because sometimes, rarely is there already a collaborative process ongoing. Sometimes you have to make that initial contact with the other side. I think it's a good idea to send that initial letter, not in some type of pro forma way where, my client prefers negotiation to litigation because everyone says that and it's not always actually meant. But take that as an opportunity to seek solutions, invite input, talk about process, offer some names of other collaborative practitioners, right, who are taking on clients. Avoid the instinct to make accusations or repeat narrative that's going to entrench positions. And sometimes, if you're feeling particularly spicy, maybe identify some of their needs, right? Identify some of the things that will make them feel a bit heard and seen. And then you have buy-in. And then they're going to go have that referral or that consult with a collaborative professional who is going to come on the file and, create a really engaging and successful process. So that's really how I like to approach that whole idea of selling, collaborative practice.
Spicy. I like that. Let's run our next poll, see what our audience is thinking. And thank you, everybody, for sending in your questions. We're answering them as they come in, and we've got lots more that we're going to get to. So who should be responsible for promoting collaborative practice in Ontario? I'm going to get on my soapbox for a minute because I think, I've worked with other collaborative practice groups. This is hard to promote, right? Because if you're promoting collaborative practice, people aren't searching collaborative practice. They don't put that into the Google machine when they're going through the divorce. They don't even have that lexicon in their mind. So this has been an issue that local and international practice groups have been struggling with. And let's see what our audience thinks, and then we're going to get into some more substance here. Lawyers, 30%, other professionals, 9%, OECP, IECP, 4%, Law Society of Ontario. Good answer. Local practice groups, provincial and federal government, 17%. Certainly, I think this should fall on government. Local practice groups don't have the budget or the expertise to do that. Ontario had that, Good Things Grow in Ontario campaign, effective. Tourism Ontario, also very effective. Divorce Act is federal legislation. The federal, government of Canada has a duty to help here. And it's going to alleviate the court system, right? It's going to help us with backlog. What do you guys think of these poll results? Carrie?
I think it should be all of the above. I think everybody should be promoting CP in Ontario, but I do think the Law Society, the government, and our provincial and national groups absolutely should be taking the wheel on this and getting things moving. There's only so much you can do at a local level, but the more people that know about collaborative practice, I think the better it is. We need to get people to understand that the TV is not how family law works.
And let's go to the president of the IACP, Mr. Galbraith. What are your thoughts on this?
Well, when the government embraced family mediation, it really made it mainstream. Everyone started to embrace mediation and knows about it and supports it because the government has funds it and promotes it on their websites and so on. And that's the level of support that we need in this province. In other states, some states have passed laws recognizing collaborative practice called the Unified Collaborative Law. And that has made a big difference in the expansion of collaborative practice. So the Law Society needs strong voices who will push the government to support collaborative practice. So I know you're running as a bencher, Russ, and I really am so thrilled that we're going to have a collaborative practice professional as a bencher promoting collaborative practice.
Well, the election is going to be, voting starts soon. Talk to your bencher candidates, ask them what they think about this issue, and make your choice. But thank you, Brian. Okay, let's get into audience Q&A, and we kind of shuffled these together by category. We're going to talk about process. So, David, how does collaborative practice differ from mediation?
They are different in the scope of the professionals involved. In the collaborative model, both parties have lawyers who assist them through the process. That's not always the case in mediation. To pick up on a theme that I think Carrie mentioned earlier, I think what collaborative practice does is it brings together the best elements of mediation into a model that involves other professionals, right? And so you don't always have access to a financial neutral in mediation. Sometimes mediators have varying degrees of skill and knowledge with respect to family law, with respect to finances and family dynamics. And that can be a lot of work to put on people searching out the right professionals at first instance. And the benefit of the collaborative model is we bring those professionals together through our own networks. And so you have a quality of expertise and knowledge that is really deep.
Excellent. Thank you for that. Okay, we're going to jump ahead to what are the best referrals for you? So, Brian?
Well, there's some confusion out there that collaborative practice is only for those parties who are so amicable and come into your office holding hands. And that is just not true. Collaborative practice is a fantastic, robust process that helps resolve conflict. So I need parties who have a conflict, who have issues, who need help getting their matter resolved. Now, the parties that there's a very small percentage of parties that just want to do battle, and those are the ones that need to go to court and duke it out for years and years on end. That's maybe a 5%, 3% of the population. The majority of people just want some help to get their matter resolved in a timely way and cost effectively. So anybody with family law issues that is willing to come to the negotiation table is a good referral for me.
All right. So keep your questions coming in, audience members. They've been excellent. There was let's go to intimate partner violence. So is collaborative divorce appropriate where there's been intimate partner violence? Does the training include recognizing power imbalances? A very important question. Jonathan, can you help us with this one?
For sure. I would say yes. Generally, collaborative divorce is appropriate for either high conflict or families where there has been violence, including coercive control. Doesn't make those cases easy, but I think having a team approach on those cases can be really, really helpful. And the training does include a little bit about family violence and recognizing power imbalances, but I would recommend a couple of things. If you are going to have a case like this, always bring in a family professional, a family neutral. And second of all, get yourself some more training. There are excellent courses through the Ontario Association for Family Mediation on that are open to everybody. You don't have to be a mediator to take that training. The Family Peacemakers Conference that happens every year and is coming up in May always has an excellent day, usually a full day of training on the subject of screening for power imbalances and family violence. So I'd recommend that, but generally the team approach is good. And better than, say, going to court where, you know, your process might be dragged on for years instead of getting to a quick resolution with people there to support both the victim of the power imbalance as well as the person who is engaged in coercive control behavior. Having their lawyer and the family neutral and the financial neutral all on the same side, trying to correct that behavior and manage it can be really, really helpful.
Okay, I'm just going to review some of the questions we've answered because I think they would be helpful if we spoke about them in this setting. So Brian, I'm a lawyer in Ontario. Do I only need to take the course? And then can I start doing collaborative practice? So once you get training, can you start being a collaborative lawyer?
Yeah, absolutely. But you know, it's like any professional practice. You need to continue to hone your skills and continue to take training and courses, attend conferences like the upcoming Ontario one, and IACP's International Forum is coming to Ontario in October. That's a great learning opportunity as well. So yes, once you have taken the course, you can start practicing. But one thing that I would really recommend is that if you haven't taken mediation training, that is really helpful to being a collaborative practice professional. So mediation training would be the next thing to do. And then you just join a practice group, and because those practice groups have great opportunities to hone your skills and continue to grow as a professional.
And once you work on a couple teams and you get known, then people refer you work. It snowballs after that. When that came in, once the separating partners have their own lawyers, who finds the neutrals? Jonathan?
Usually the lawyers will reach out to me and ask if I want to join their team, and usually they'll have a conversation with the clients about that. Sometimes they'll send a bunch of names to the clients and say, hey, you guys should pick one, and then we'll reach out to them. So I would say mostly it's the lawyers. What about you, Carrie?
You know what? I think it depends where the file is coming from. I know so many times I get clients coming to me firsthand, and I'm setting up the team and where I'm saying this is a family professional you can talk to. If they're not a good fit, I have others. Here are a couple lawyers I'd like you guys to talk to. Again, if they're not a good fit, happy to find somebody else that fits for you. But I think it really depends on where they're coming in from. The collaborative files come from financial professionals, family professionals, and legal counsel. It's not a one-way street.
And, you know, pre-pandemic, it usually be geographic, right? Who's in the community that can help. Now we do a lot of it by Zoom. I know that the lawyers usually try to match professionals up with the clients, just in terms of their personalities. But Okay, so let's go to a couple questions up. What strategies can be used to overcome impasse in a collaborative practice? I think David lost his internet, so we're just going to jump ahead a little bit. So Brian, can you take care of that one?
Oh, there are so many strategies that we use. So first of all, the team will come together and discuss what's going on and try to understand the dynamics of the negotiations and of the couple, and then they'll look at what could be appropriate. So sometimes a strategy is the family professional will meet with one person with their lawyer in attendance, and then they'll go to meet the other person with their lawyer present. And that sort of shuttle diplomacy can sometimes work. And likewise, the financial might do that sort of a regime. Sometimes it's the financial and family without lawyers present that is meeting with the clients individually, or meeting with them together, but without lawyers. Maybe they need to bring in an expert. Maybe they just need to park issues and let them simmer and go on to other issues that are more easily resolved. And then you come back to the difficult ones, and voila, the answer's there, and it's easy to resolve things. So there's a lot of strategizing that the team can do to overcome impasse. And that's the beautiful thing about collaborative practice, is that nobody wants to say, oh, you've reached an impasse, go to court, because if the matter goes to court, we're all out of a job, right? And so we really work hard to find a way through impasse, and we do that by working together as a professional team.
All right, let's jump ahead a couple more questions. How do you deal with opposing counsel who does not want to proceed with a full team? Brian?
Well, one of the things I've done is if they're reluctant to have a family professional on the case, I'll say, well, you might be right. I'm not sure, which is a lie, because I know that it's always helpful. But I play along with it. Why don't we just have a meeting with a family professional? Or maybe you and your client should meet with this family professional just to feel it out, just to see whether you think they would be helpful. And every time they come back and say, yeah, my client really loved meeting the family professional. And same with the financial professional, is get them involved in the process of getting the client on board with using their services. So that's what I do. Because I never do, I have many years ago done a case without neutrals, but I always now use both a family and a financial professional. And I just tell them, this is what we need to do. But if the opposing lawyer is unwilling, that's all. I'll just get them into the office of the family professional or financial professional, and they'll do the persuading for me.
When you have a full team, the role of the lawyer changes, right? You're wearing the hat of a general contractor at that point. So what I tell opposing counsel is, I don't want to do the financial statement, right? Carrie could do it for half the price it costs me. It's going to save our clients money. I don't want to draft a parenting agreement. Jonathan can meet with the parents at home and get a draft agreement ready for. It's just more efficient just to have the full team. That's the way I sell it to counsel who are reluctant to get involved.
I think it sells itself.
That's right.
Yeah.
Yeah.
Plus, there's a question here that I think maybe we should generally answer, which is
Sure.
that if you're in your geographic area, you don't have neutrals. How can you get neutrals involved, and how do you find out about neutrals? And that's one of the beautiful things about the pandemic. If there was ever a silver lining to that period of time, what the silver lining was that we all started to use Zoom and work online. And so there's no need for someone to be geographically close by for them to participate in the case. One of our colleagues, Bev LeMay, lives in the Toronto area, but about half of her practice is in Sudbury, and has been for many years, long before the pandemic began. And she just appears in Sudbury on Zoom. And so the way to find out about collaborative professionals is to go to the Ontario Association of Collaborative Professionals, and they have links to all the practice groups in Ontario. I think there's 19 practice groups. So you can go to their websites, and everyone is designated as a lawyer, a family professional, or a financial professional. So you can find someone to help you out.
David, what's your take on this question we have up here?
Well, it's so personally relevant to me because I live in an area where we don't have a vibrant collaborative group. And there's been some great suggestions offered. I think one that has worked well is looking to other, collaborative practices. A file. And I think more generally, you need to be someone that other lawyers want to work with. And if you are someone that other lawyers want to work with, you will create a sort of self-fulfilling rationale for why a collaborative model works with you in it.
Good point. All right, so let's talk about selling CP. Brian, how do you convince the other spouse to take a collaborative route? I know you got a really cool way of doing it by designing an email for your client that they hand off. How does that work?
Yeah, well, one of the keys to it is talking to your own client about their spouse and finding out what's important to their spouse. Too often, especially lawyers, we don't find out about the other party, and we really need to carve out some time to get to know what the wants and needs and worries and concerns are of the other party who's not in the room with you. And then what we do is we'll write an email, and it's an email to my own client explaining the benefits of collaborative practice and why I recommend it to them. But it also addresses why collaborative practice would meet the needs of their spouse. So you found out what their spouse's concerns are. Let's say their spouse's concerns are parenting issues. They're concerned about the children. So then you can say, you've told me that your spouse is worried about the children being harmed through this divorce process. And that's why your spouse should really consider using the collaborative process, because you're going to work with a family professional who will be able to assist you to develop a parenting plan that's in the best interest of the children. So you send this email with maybe, I always put some names and email addresses and websites of other collaboratively trained lawyers, because I explained, look, not every lawyer is trained collaboratively. Some lawyers take every case to court. So you need to find the right kind of a lawyer. So I put links to our practice group website and the IACP website, and also links to some other lawyers that I've had successful cases with. I send the email to my client, and then they pass it on to their spouse. And for some reason, it works. There's not a defensive response to an email that's been addressed to my client. Whereas in the old days, I used to send a letter addressing it to the other party. And when they would get that letter on my fancy letterhead, they would just become defensive and think, oh, this is a tactic to really take me to the cleaners. I'm not going to do this. It's only going to benefit my spouse. There's this defensive negative response. But sending the email to my own client, which they share, just doesn't get that defensive response, and it leads to more cases.
We forget, a lawyer's letter showing up at somebody's house is a pretty intimidating experience, right? Like
it's like an incoming bomb, man. It's like a
fight or flight. But if you have, if you go to your spouse, say, my lawyer's a really nice guy, he wrote me this letter about the process, and you hand it over, you take away that fear, right?
Right.
Yeah.
Let's face it, Russ, a lawyer's letter is like getting the brown envelope from the CRA. You just don't want to open it.
That's right.
Is this an audit or is this a payment remittance form? Right? I know what's in there. Okay.
How much are my own taxes?
We have a poll. How does collaborative practice fit in your, we have an audience out here. Let's see what they're thinking. 10% to my 50% of my practice, 100% of my practice, 3. I would like to learn more about the training. 50%. Well, you're in the right place. We're going to talk about that right now. Let's go to slide 51. Talk a little bit about training, and then we're going to bring this train into the station. So Brian, can you talk a little bit about this and what does our audience need to know about training?
Yeah, we the trainers of Ontario sat together on Zoom, and we created a curriculum that we said this is what we need all professionals to learn to be collaborative professionals, and it's a very robust curriculum. And in the old days, we made some of it optional, and we found that didn't work. We really needed everybody to have the whole 5 days. In the old days, it was 5 full days of in-person training. Now we do it on Zoom, broken up in smaller chunks. But so there is a curriculum, and if you go to the Ontario Association of Collaborative Professionals website, there is a calendar there that lists all of the trainings. There's, I believe, 4 training groups. We have one. We're the best group, of course, but there are 4 groups.
So humble, so humble.
All excellent professionals. All have lots of experience and are offering courses at a variety of times during the year. So one of the criteria you might look at is whether you prefer it to be in person or on Zoom. Ours are on Zoom, others are in person, and some are longer days, so that might be better for you than ours, which are half days. So yeah, here's a slide about our upcoming training, and we've offered a discount code of 10%. So what you do is when you go to the website cptraining.ca, you can click to register, and there's a spot where you can insert the code to get a 10% discount, and that code is Family Law Now Live. And that will be available until April 7th, because we'd love to get some people signed up and have an opportunity to take this training. That website, cptraining.ca, has a full description of the training. It goes through the curriculum, and it has a great explanation of what you'll be experiencing during this course. So if you're 50% of or a large group of you said you wanted to learn more about the training, just go to the website, click on the tab for introductory training, and you can learn more about what we're offering in our courses.
Shannon's back. That means we're close to the top of the hour. 5 seconds or less, Brian. How many cases that are collaborative settle?
86% of cases settle, and of the 14% that don't settle in the process, some of those have partial settlement. Less than 1% actually ever go to trial, because they're able to find some other process to resolve them and keep them out of the court proceeding.
Back to you, Shannon. Welcome back.
Thank you, Jonathan, Carrie, Brian, and David for joining Russell on the panel today. And thank you everyone in our audience for joining. We know we have a lot of family lawyers in the audience today, so just wanted to mention this survey that Professors Birnbaum, Bell, and Houston are undertaking currently to study the pandemic and the effect of that on the practice of family law and the use of virtual family court proceedings, including questions about the experiences and views of the family lawyers about policies and how that should be adopted going forward. So please, if you have the time to fill this out, if you'd like to share your views. And I want to thank again all of our panelists for being here to share their knowledge and experience, and also just want to extend our gratitude to all of our audience members. We hope we have the opportunity to host you again soon.